To some extent, it may be correct, but that is not the exhaustive definition. We cannot rely upon that. You see, my case falls within the list, and therefore it's a public duty. Whether it would be a plausible explanation, plausible answer. Lawyers who have, yes. Yeah.
I think considered as a public duty, the person who is serving for that.
Any other? Yes.
Of course, but ultimately we'll have to enforce them. So,
right, there cannot be gainsaying the fact, denial to the fact that public duty comprises of two words, public and duty. A duty which has a semblance of, or a duty which is related to public, has to be a public duty. Now, public duty, when you sometimes what happens, I also as a lawyer believe that we very conveniently, very comfortably use certain words, phrases, without actually deciphering the meaning, actual meaning of the public duty. It has undisputedly, this word, this phrase has not been defined anywhere, public duty. But it can be taken that yes, if it relates to, it has nothing to do with the fundamental rights, it has nothing to do with the directive principles. It is public duty means anything which is concerning public and mass, in the sense health related to public, education related to public, security related to public. So this is how one can carve out a definition of public duty in the sense. So education undisputedly is a public duty. Yes. Fundamental duties. Fundamental duty, can you? 51A, yes, 51A, fundamental duty. But that is again a part of this. Public duty is a more exhaustive word.
broad outline.
Broad outline, yes, you're right. Fundamental duties.
Yes.
Fundamental duties and
So,
do you have that constitution with you?
yeah, I did in my phone, sir.
51A.
Yes.
Can you open 51A here?
Sir, to abide by the Constitution and respect its ideals. Second one is to cherish and follow the noble ideals which inspired our national struggle. Third one is that to uphold and protect the sovereignty, unity, and integrity. Fourth is to defend the country and render national service. Fifth one is to promote harmony and spirit of common brotherhood amongst all religions, linguistic and regionals. Sixth one is to value and preserve the rich heritage of our composite culture, and so on, sir.
So it shall be, this is, if you read Article 15(1)(a), this duty is of every citizen.
Yes.
So whether it would classify, it would fall within the definition of public duty or not, that would again be a question, because certain duties, these are duties enshrined in the Constitution for us. Suppose, assuming you file a petition,
Yes, sir.
and there's a question which is posed to you by the court, that you say that your case does not fall within the violation of fundamental rights. You are not pleaded their case, but you say that public duty, you have filed a petition against a private body, and you have made an averment in the petition that yes, though it has not been filed against any person who falls within the definition of a private against the state, but it has been filed against a private person performing public duty. And the question is, and you say that yes, my case falls because my case falls within Article 51A. So whether 51A, with the aid of Article 51A, can you say that, yes, sir, since this is the duty of every citizen, it is your duty. In fact, that becomes your duty also.
Sir, it can be said it is a reference and certain ideals which has to be followed.
Yes, yes, that's a broad
It
thing.
is not to be justifiable in court, sir.
No, no, no. But ये क्या है? जैसे there are certain things which are intangible in the Constitution of India, in the sense they have to be understood by emotionally, if I use the word.
Yes.
ये हमारी duty है, हमको स्वच्छ रखना है. But you cannot, for violation of every fundamental duty, can you file a petition under Article 226?
No, sir.
So that answers the question that it will not fall within the public duty with the aid of. It could have semblance of 51A.
Yes, sir.
It could be touching upon 51A. But that does not mean that in order to qualify within the definition of a public duty, can you take the aid of simplicity? Can you take the aid of 51A, Article 51A? That this my case falls within Article 51A, and therefore it is a public duty, and therefore the writ is required to be issued.
So if it's the issue, certain elements can be taken.
Yes, certain elements.
To define it, yes, to a certain extent.
Yes.
That can be considered a public duty. Governance issue.
Look, you have filed a, I mean, my case, as far as this aspect of the matter is concerned, we are discussing with the topic that you have filed a petition not against the government, not against the statutory authority, not against a local authority. You have filed a petition against a private person. And you claim that the private person is required to perform certain public duty. The question is, what is public duty?
Yes. But so, it is a governance issue that concerns a government which is en masse for the people. So,
yes,
it is considered a public duty.
To a great extent, you are right. In the sense that if you are able to demonstrate that the functions the private person is required to perform, they are akin to the performs that are required to be performed by the statutory authorities, by the government, and therefore a public duty. So what I'm, by way of this interaction, what we are trying to churn out is that what exactly is public duty? Because this is a problem, because going against the government, going against the statutory authority, against the local authority, nobody asks you how this petition is maintainable. But the question arises when you file a petition against a private person. So the words used for any other purpose, that qualifies. Number one. Number two, you can argue on this point that yes, my case, the authority against whom I have filed the petition is required to perform certain functions which are akin to public duties, and public duties are duties which the government has to perform, which directly connects, which directly affects the public en masse, and therefore it's a public duty. Public function, public duty. Now we come to specific writs, because I have the audience, assorted audience, in the sense some of you have put in 1 year practice, 2 years practice, and I see some of the advocates whom I see as my opponents also. So therefore, the assorted audience, so I am not addressing an audience which can be said to be a clean slate, having a clean slate of mind. So these are habeas corpus, mandamus, certiorari, prohibition, quo warranto. I hope everybody here forming part of this audience is aware of all these writs. But here, for the purpose of habeas corpus, as you all know, habeas to have, corpus is the body. So, writ requiring a person to be brought before a judge or a court for investigation of a restraint of a person's liberty used as a protection against illegal imprisonment. Then mandamus is a command or order. Certiorari, the certiorari is normally used for the purpose of, it is very commonly used that certiorari means something which is to Now, this is something very interesting in the sense that these are questions which we are sometimes confronted, which we are posed by the courts before whom we are appearing. Locus standi. Now, everybody here is well aware of the fact that in every case, a person has to satisfy the court unless and until you're not filing a PIL, where also in PIL also you have to satisfy that you're not into your private rights are not being used in the garb of PIL. Sometimes the PILs are dismissed solely on the ground that though you have claimed that it is a litigation which involves public interest, but sometimes the High Court is able to trace out if there is a semblance of private interest, then it is declothed with the character of PIL and you suffer dismissal on the sole ground that though the cause which has been espoused by way of PIL had merit, but solely on the ground that it was in the garb of private interest that PILs are dismissed. Now we come to this locus standi. Person aggrieved. Suppose your fundamental rights are violated and you file a petition, this no undoubtedly where the ex debito justice, person aggrieved is entitled to file writ petition. Now stranger, even the stranger, if he files a writ petition, but he is able to demonstrate, because again this would fall within the PIL, the clause of PIL, busybody and meddlesome interloper. If you petitions sometimes are dismissed with heavy cost on the ground that if the court reaches to this conclusion that yes, though there's a PIL, though it's a PIL espousing a public element, espousing a public interest cause, but yes, he is a busybody, so the petitions are dismissed. Then we come to writ against government, writ against legislature. We'll come to this aspect later. Now we come to pleadings, which is very important in a writ petition. Now pleadings, they are vehicles of your thoughts. Only by way of pleadings, you are able to deliver your grievance to the court. Now, what exactly is the difference between a pleading in a writ petition and a normal pleading in a civil suit? Can anybody from the audience? Because these are questions which are daily, we have to deal with, every lawyer has to deal, and the court is very right in asking such questions, because ultimately these are the topics which would cover which would make you or make your cause effective and efficacious. Because if you want to have an efficacious remedy, you have to be, because sometimes what happens, we get an LLB degree, we start practicing, and at later point of time, when we are confronted with these queries, then we realize that yes, these topics we had never read or we had never pondered upon or we took it very casually. So these have to be understood, because these are the topics which we tend to miss. We escape, our eyes escape these topics. So pleadings in a writ petition, pleadings is a word which is interchangeably used everywhere. But there is a lot of difference between pleading in a civil suit and a pleading in a writ petition. Now, can anybody answer these? Can anybody? Yes. Yes, very correct. Yes. Yes, you're correct. Now, pleadings in a civil suit. Normally, there are two in a civil suit. If you see, in order to reach to a judgment or decree, there is one barrier when you file a civil suit. The first barrier has to be crossed. That is, which is the first barrier under in a civil suit? Cause of action, that test under Order 7 Rule 11, in the sense that suo motu also, suppose you file a civil suit, does the court have the authority, jurisdiction to dismiss or reject your plaint at the threshold? Yes, the answer is yes. If it does not disclose a cause of action or it is barred by any law, then yes, the court has the jurisdiction to reject your claim. I'm using the word reject, I'm not using the word dismiss. Reject means yes, it does not qualify for further entertainment. If you insert a CD in a DVD and it is rejected, in the sense that it is returned back, because it does not qualify to be called a plaint, because it does not disclose a cause. I may not have pleaded anything or I have not led evidence, but it was the duty of the defendant. The duty cannot be shifted. The burden cannot be shifted. The onus cannot be shifted on the defendant. The plaintiff is required to prove his own case. And that can be done only with the aid of pleadings and evidence. If pleadings are there, evidence is not there, judgment cannot be obtained. Suppose if you have evidence, but you have not correctly pleaded in your suit, in your plaint, then also the court can reject, can dismiss your plaint on the suit on the ground that though there was pleading, but evidence was not led. Though there was evidence, but it was not pleaded in the plaint. So pleading, in so far as the civil suit is concerned, has to be a conjoint reading of pleadings plus evidence, and then only you are entitled to a decree or a judgment in your favor. Now, in a writ petition, or for that matter, election petition, material facts have to be demonstrated. And those material facts, again, the same principle would apply. That yes, in support of material facts, the evidence has to be laid. Now, evidence sometimes it sounds very weird that evidence in the High Court, in the writ petitions, so evidence in the nature of documents. So if you go by the definition of evidence under Section 3 of the Evidence Act, that contain documents. So the evidence has to be there. Because normally when you file a writ petition, you are required to support it by way of documents. Merely by filing a writ petition and saying that I want a relief of mandamus without a single document with them. So the relief is almost impossible. Yes, any query? Anand, any query? So, as far as civil suits are concerned, facts, material facts, relevant facts, necessary facts, they have to be mentioned in the civil suit. And they have to be categorically proved by way of evidence, unless and until the complete combination of pleadings and evidence is not there, you cannot have a fruitful decree in your favor. And that applies to the writ petitions also. In writ petition, material facts have to be pleaded and that have to be supported with the aid of documents. And yes, of course, pleadings should be signed and verified by the parties. Pleadings should be construed and interpreted liberally. Pleadings may be permitted to be amended with the leave of the court. In the writ petitions also, in the civil suits also, the pleadings, you can amend your pleadings. Now this, we come to Article 227 of the Constitution of India. Now, what is the basic difference between Article 226 and 227? Earlier, when I joined the bar, all petitions were addressed Article 226 oblique 227. And that is, that practice, sometimes even today, we see the petitions, but there's a remarkable difference in Article 226 and 227. Can anybody from the audience, Article 226 and 227? Yes, very good, Jayesh. Any other difference which any other member of the audience wishes to point out? Yes. Very interesting point in the sense, but what you just have said, does it find any of that content in Article 227? Like, yes. No, control the. Now, whether control is a very exhaustive word in the sense, suppose the judge misbehaves with a lawyer or a client, can the supervisory jurisdiction under Article 227 can be invoked? Yes. Suppose you file a civil suit. Suppose we take an example. You file a civil suit and no order is passed. Okay, you file a civil suit. There's no order of dismissal. No notice has been issued. It is lying idle before in the court of the judge. No further date. So there's no, practically speaking, there's no order. So can Article 227 can be invoked or not? Can be invoked. So for that, the order is not required under, you cannot say this, the court cannot dismiss your petition under Article 227 on the ground that since there is no order that has been challenged here, and therefore it does not qualify under Article 227. So one thing is important, that this is a supervisory jurisdiction conferred on the High Court. This power is not even vested with the Supreme Court. Suppose authority taking cue from the Article 32, you say that, okay, the authority is not performing and I'll file a petition under Article 32. And Article 32 is very vast. It would embrace within itself, it would take within its sweep the provisions of Article 227 also. So whether this petition, a petition which ought to have been filed as a petition under MP under Article 227, can it be filed under Article 32? So this power is exclusively vested with the High Court, number one. Article 227, supervisory. The High Court acts as a watchdog. It guards, it protects the interest of the citizens, of the parties, in fact, the parties to the litigation. and ensures that the courts and tribunals are working within their limits. They are not crossing their jurisdiction. They are not crossing the Lakshman Rekha, which is provided under the statute. So, number one, this is the exclusive jurisdiction of the High Court. Now, normally we see any order that is passed, suppose an order under Order 6 Rule 17, you file an amendment application that is rejected by the trial court. Can you file an MP? Interesting. Yes, those who said yes. How? No, man, you have mixed up too many things. Number one, I said your application, you file an application under Order 6 Rule 17, that is rejected by the trial court. Can you file an MP or not? That is the question. Now, one, you say that it can be filed. Ground number one. What is your ground number one? Does Article 227 say that only the list that is finally decided would qualify to be challenged under Article 227? Then, so bear reading. Suppose you file your petition before Judge X, and Judge X puts a question to you. Yes, why have you come under Article 227? What made you file this petition MP under Article 227? What would be your argument? What will be the ground? That it has finally been decided? You're mixing up things. First, read the provision under which you have filed this. Read it at least 5-10 times. Ram Jethmalani, I am told, used to read his file at least 10 times. And most revered Mr. J.P. Gupta, senior advocate, he used to read, criminal law, he was authority, final word on criminal law. And even when a challan used to come to him, he would read Section 154 of CRPC every time a challan would come to him. So that practice has to be imbibed. So reading Article 227, can you say that, yes, my petition would be maintainable because it is finally decided? Yes. Anybody else? So is there appeal provided under for rejection for a dismissal of application under Order 670? If miscellaneous appeal under Order 43 Rule 1 is provided, then certainly MP cannot be filed. So that is, I agree. But if suppose there is no remedy provided under Order 43 Rule 1 of CPC, can MP be filed? The question is why and how MP can be filed. Why? Supervisory jurisdiction. So you mean to say that suppose your arguments have not been considered, the judgment that you cited has not been rightly appreciated or considered, and therefore you can invoke the supervisory jurisdiction of the High Court under Article 227? Yes. Why and why not? That's the question. I'll give you an example. Recently, I am dealing with a matter. X place, Y client. We are defendants before the court. And it's a probate matter arising out of a will. A brother's family on one side and three sisters on the other side. The brother's family, the brother has expired, and on the basis of the will of their father, suppose we say A brother, B, C, D sister, A, B, C, D, their father is said to have executed a will. Now, on that basis, and on that basis of the will, the family of A, that is the son, they claim that all properties have been given to A, that is the son, and no share has been given to B, C, D, that is the sisters. Family of brother A has expired, so his wife and his children, they have filed a probate application. The sisters say that the will is forged. Reply has been filed. They have also raised the question of jurisdiction, because the place X where the application has been filed, the sisters have claimed that the person who had executed the will, that was not his last place of abode, and therefore the jurisdiction has been wrongly invoked. Then certainly there's a change of mind in one sister. She says that earlier I had, along with my two sisters, I had raised this plea that the will is forged, but now I have come to realize that this will is not forged. And she files an application that my name be removed from the array of the defendants. And she files an application under Order 1 Rule 10 along with an affidavit. The other side, in order to ensure that the sister now again does not change the side, so therefore they move an application under Order 19 Rule 2 for cross-examining that sister who has now changed her stand, to cross-examine her, so as to ensure that her evidence is recorded before the court. We raise an objection that jurisdiction point has not been decided, and this affidavit that has been filed along with an application under Order 1 Rule 10, that is not even required. So it does not qualify within the definition of evidence. It is not evidence where 19.2 can be invoked. 19.2 can be invoked only when, because 19.2 says that if the court wants certain fact to be proved by way of affidavit, affidavit is not evidence, number one. But the court may exercise this option by saying, calling upon a party to, okay, you file an affidavit, we want to have the evidence on this point, and therefore you file an affidavit. So there the affidavit takes the partakes the character of an evidence. So since because the court has directed affidavit to be treated as evidence, and therefore the other party can cross-examine. So that cross-examination was also permitted. So we filed an MP saying that there's a jurisdictional error in this case. Ultimately, that MP was dismissed on the ground that this is a dispute between A and B, and what prejudice has been caused to you, and therefore the MP. So we are before the Supreme Court, and now the larger question is, in what matters Article 227 can the court exercise its jurisdiction under Article 227? That is the point. Every dispute pertaining to A and B, suppose the parties are A and B before the court. A makes an application, it is decided in A's favor. B makes an application, it is decided in B's favor or A's favor. Can you invoke MP just by saying, look, our judgments have not been considered, our pleadings have not been appreciated, our point has not been taken into account, or the findings are perverse? Can you file MP? Unless and until that jurisdictional aspect of the matter is there. Shalini Shyam Shetty, 2010 Supreme Court. The Supreme Court, that's the only judgment which is right now holding the field. Shalini Shyam Shetty, 2010 Supreme Court. That deals with jurisdiction. So supervision of the High Court under Article 227 is not with regard to the list between the parties. some jurisdictional aspect has to be, some semblance of jurisdiction has to be there in order to invoke the powers under Article 226. So, filing of an application, its dismissal, perverse finding, judgments not considered, that cannot be the plea that could be entertained by the High Court under Article 227 unless and until you are equipped with the argument, with the point that there is a grave jurisdictional error committed by the court below. Only then Article 227 could be invoked. Any other query on this or any other? I mean, I'm open to, because this is, as I said, law is dynamic. Yes. Yes, it's a very pertinent question in the sense that if you file a petition under Article 227, there has to be some list, but that list has to have an element of jurisdictional error in it. As I said, my case, the case which I just narrated, it pertained to an application which was filed under 110. Then we moved that this cannot be, the jurisdiction application should be decided first, because if the court is not having jurisdiction, it is proceeding with the trial of the matter, then certainly it is exceeding its Lakshman Rekha. I mean, the court should decide the application for jurisdiction first. I mean, there are myriad number of judgments on this point that jurisdiction and limitation should be decided first. In fact, jurisdiction, limitation, even in the civil suits also, limitation, either the court comes to the conclusion that yes, it has to be decided as a preliminary issue. Because if you are able to read the plaint and the plaint says, okay, it is within limitation, and the other side raises an objection with regard to the limitation, then also that has to be decided first as a preliminary issue. Because there is an element of law and fact involved in it. Then it has to be decided under Order 14, Rule 2, Sub-Rule 2. Then it has to be decided as a preliminary issue. So the point is, jurisdictional aspect of the matter has to have a precedence, a priority. It has to be a pivotal point in exercising Article 227. Grave injustice. Every application, dismissal of every application, it results into grave injustice. One party, if you cannot claim that you are very happy with the dismissal of the, there has to be injustice to you. There must have some injustice caused to you. So in every case, an MP cannot be filed only because the grave injustice has been caused to him. How do you qualify how do you fall within the definition of, or within that phrase of grave injustice? Grave injustice would be caused when the judgment would be filed, passed against you. You have the grave injustice can be mitigated by filing a consequential amendment application. But suppose amendment application is allowed, you have the opportunity to file a consequential amendment application. So where is the question of grave injustice? Injustice must have been caused to you because your application has been dismissed. Your client is not happy, that means injustice has been caused to you. MP, you mean? If you have a remedy of revision, then certainly if you have a remedy, so you cannot go in MP because that can be corrected. There's a statutory remedy. Though Article 227 is just placed after 226 in the sense that it is very close to the Brahmastra. 226, if you use it as a Brahmastra, because 226 powers are extraordinary. 227 is not extraordinary. But it is juxtapositioned Article 2, it has been juxtapositioned with Article 226 in this sense. That does not mean that MP can be filed interchangeably with civil revision. That you feel that the roster is not good of civil revision, and therefore you cannot file MP with the MP on the ground that civil revision should not be filed in this case. There are chances of limited relief being granted. Yeah, you were wrong about Alok Kumar Chaube's case. Like, yes. Yeah, I mean, you're aware that where the virus is challenged, writ petitions can be filed. Where principles of natural justice have not been followed, petitions can be filed. Fundamental right, and there are other reasons which have been, and right from Whirlpool's case and all. I mean, petition, but still. These are all matters of where the discretion has to be exercised when the alternate remedy is there. Where the discretion has to be exercised, this is up to the court. Because you cannot, as a matter of right, claim that, yes, there is an alternate remedy, but writ petition has to be filed because my fundamental rights are being violated. So it's a matter of discretion. The court has to, you have to invoke the extraordinary jurisdiction by canvassing this thing, by putting up before the court that grave injustice would be caused, and the jurisdiction has to be exercised because the alternate remedy cannot be said to be efficacious. So that material, that depends on your art of advocacy, pleadings, and many other factors. Yes. So, then lastly, we come to this. Manisha, this one there. Res judicata. Res judicata, as you must have come across this word many times, that an issue which has been decided between the parties earlier cannot be re-agitated before the court, and therefore the relief which is already decided between the same parties, that cannot be re-agitated and therefore cannot be re-adjudicated. So this is what, suppose the writ petition is filed in limine without deciding any point. Can you file a writ petition again? Say suppose writ petition is filed it is dismissed in limine and no writ appeal is filed. Then can you file a writ petition again? No, on the same ground. Suppose if you want to file it on the same ground, then yeah. Yes, suppose the writ petition in the earlier round of litigation is dismissed in limine without deciding any lists, without deciding anything. Then suppose if it is dismissed on X ground, suppose you have raised A, B, C, D grounds, and suppose the writ petition is dismissed on A ground. Can you file the same writ petition eliminating A and remaining grounds? Then yes, because the issue with regard to A ground has been decided. So res judicata would not apply to the grounds B, C, D. Yeah, that will depend on the facts of the case, because the points that are being re-agitated in the form of, suppose, like if I come to the basic question again, A, B, C, D filed, grounds A, B, C, D, the court dismisses your petition in limine on the ground A, B, C, D not touched, then you eliminate ground A and you file writ petition on the ground B, C, D, then what is the position? So the point is, once the basic principle of law is, once the court has decided a matter on a particular issue, then that question cannot be re-agitated between the same parties and the court cannot be burdened to decide that point which has already been decided by it in the earlier round of litigation. So then we come to the speaking order. How does the order qualify the phrase speaking order? So the court thought that only by dismissing ground A, because you do not qualify to go to the grounds B, C, D, and therefore we are dismissing your petition on the ground A itself. So that could be a speaking order. In the sense, the court did not find it plausible or appropriate to go to grounds B, C, D. Then you have to make out a case that despite the dismissal on the ground A, the court ought to have, that's a ground could have been, if you go in appeal. So appeal, you have to say that the grounds A I had raised A, B, C, D. The court ought to have decided all my grounds. And dismissal of my petition on the ground A was not a bar in not deciding my grounds A, B, C, D. So either you could file a writ appeal. So I believe the basic I have tried to convey through my a small knowledge and meager experience, something on the writ jurisdiction and the aspects touching writ jurisdiction. So we can we can have now proceed with the interaction round. Any queries on matters relating to law besides writ jurisdiction also? Yes. You're right. Contempt is only a matter where you trigger, you just invoke, you just inform the court that your order has not been ordered. It's a matter between the contemner and the court. Under contempt jurisdiction, it is for the court to decide that our orders have been actually violated and we have been hurt by the null violation. Yes. So the relief cannot be sought in a contempt proceeding. But yes, after the representation, if you say that my representation as was ordered by the court to be decided within a particular time frame and it has not been decided, then certainly you can file, because then the bar of res judicata would also not come in your way, in the sense that nothing was decided earlier. So yes, in fact, contempt would not be the right remedy. Contempt could only be a source of information to the court that what is happening to your orders. Yes, there's no bar. Both can be exercised, because certainly the relief has not been provided to you, for which contempt cannot be said to be the remedy. And filing a writ petition would not deprive you from filing contempt, informing the court that your order has not been complied with, and therefore the authority needs to be dealt with sternly. Can we finish off the session?
जैसा पार्टिसिपेंट्स कहें मैं आदरणीय श्री रविंद्र सिंह छाबड़ा साहब का बहुत बहुत आभारी हूं कि उन्होंने अपने व्यस्तम समय से आप लोगों के लिए ये समय निकाला और इतनी इन्फॉर्मेटिव जो जानकारी दी है वो कहीं ना कहीं आपके करियर के लिए काम आएगी। मैं आदरणीय श्री जीपी सिंह साहब को बुलाऊंगा कि वो आभार व्यक्त करें। आदरणीय जीपी सिंह साहब।
मैं सर्वप्रथम तो आभारी न्यायिक जुडिशली कमेटी को हूं कि जिन्होंने बार के रिक्वेस्ट पर बार से जो सीनियर एडवोकेट्स हैं उनको यहाँ पर आमंत्रित कर बार को अवसर प्रदान करा है कि किस तरीके से हमने 2-3 बार जो प्रोग्राम्स कराए हैं इसमें ऑनरेबल्स के सुने हैं, लेकिन जो बेसिकल प्रॉब्लम जो आती है हमारे पार्ट पे उसको क्वेरी और उसको किस तरीके से प्रेजेंट किया जा सकता है उसके लिए अधिवक्ता का सुनना बहुत ज़रूरी है। और उनका जो हमारे जो सीनियर्स हैं आज आदरणीय छाबड़ा साहब ने जो समय निकाला है और बताया कि हमारी समस्याएं क्या है और हमको किस तरीके से बोर्ड पर प्रेजेंट करना चाहिए और किस तरीके के क्वेश्चन हमारे सामने आएंगे, क्योंकि हम जब मैटर तैयार करते हैं तो उस स्थिति हमारे दिमाग की क्या रहती है और उस मैटर की क्या रहती हैं, उन सब चीज़ों को देखते हुए हमारे प्रपोजल पर न्यायिक जुडिशरी कमेटी के द्वारा ये प्रोग्राम में हमको पार्टिसिपेशन करने के लिए अवसर प्रदान करा। इसके लिए मैं अध्यक्ष श्री हम सुजयपाल साहब का आभारी हूँ, साथ में पूरी न्यायिक जुडिशरी कमेटी के सदस्यगणों का आभारी हूँ और विशेष रूप से आभारी आप सभी प्रतिभागियों का हूँ कि जिन्होंने बार का प्रेजेंटेशन बोर्ड पर कैसा हो उससे सीखने के लिए यहाँ पार्टिसिपेशन करा है। और मुख्य रूप से मैं आभार व्यक्त करना चाहता हूँ आदरणीय छाबड़ा साहब का, सीनियर एडवोकेट का, जिन्होंने हमारे छोटे से निवेदन पर अपना व्यस्ततम समय निकाला है और इतनी सारी तैयारी करी है। और उन्हीं के साथ में मैं आभार व्यक्त करूँ उनके पूरे स्टाफ का, जूनियर्स का, जिन्होंने इस प्रेजेंटेशन को इतना अच्छा तरीके से बनाया है और ताकि आप लोगों को समझने में हर सारी चीज़ें अच्छी तरह से सीख लें। इसी के साथ में मैं आप सब आभार, आप सबका धन्यवाद हृदय से। ब्रेकफास्ट का है स्नैक्स तो सब ले चाय साथ में।
बहुत बहुत धन्यवाद सर। मैं सभी प्रतिभागियों से अनुरोध करूंगा कि हाई टी की व्यवस्था है तो प्लीज़ आप सभी लोग साहब के साथ ले प्लीज़। थैंक यू सो मच।
चार्जर भी अपने आज चार्जर सबके साथ में
जैसा
आ रहा है सर, ये क्या इसको निकाल दिया जाए।